Are we unmuted? Okay. Like all this, for example. Good morning, co-chair. Strickland, I show 10 o'clock.
Good morning. Thank you much. And I see we are recording. So
Yep.
I would like to thank everyone for their time, effort, and participation in our work before us today. We want to recognize that it is very difficult and important work, and that we appreciate and value the perspectives and professionalism that everyone brings here today. Thank you. And we will go ahead and start this meeting. If Terry, you would like to call roll.
Yes, I would. Sarah Merrick.
Good morning, I'm here.
Good morning. Sarah Duckwall.
Good morning.
Good morning. Co-chair Strickland is here. Ryan Hearn.
Present.
Good morning. Margaret, what up?
I'm here. Good morning.
Good morning, Margaret. Stacy Llewellyn.
Good morning, present.
Good morning. Emily Cronin.
Present.
Good morning, Emily. Co-chair Priest.
Present.
Good morning. Kim Schlesinger.
Good morning, I'm present.
Good morning. Director O'Day.
I'm here.
Good morning. We have a quorum.
Wonderful. So starting out, I see we have public comment, and I see that Anne Klein is signed up to comment, and there you are.
Yes, hi. Thank you. Good morning. Anne Klein, President with Majoris Health Systems, and I'm here to provide comment on House Bill 4119 in opposition. This bill sets out a mandate to MCOs that they contract with any provider willing to agree to administrative contractual terms, and removes the MCO's ability to selectively curate their network based on credentials, past performance, and demonstrated competencies in treating Oregon Workers Compensation patients. In addition to that, it really does not address the provider shortages that workers and all of Oregon is facing, and is contrary to the statutory MCO framework, which specifically sets out a responsibility to MCOs to provide financial incentive to reduce cost and utilization without sacrificing quality, to ensure treatment is appropriate, and to exclude providers who fail to meet treatment standards. This bill would remove the MCO's core tool for accomplishing both of those fundamental responsibilities, and it's also not needed. There's already a pathway for workers to access non-network care if the MCO network is for some reason insufficient, or if they have an established primary care physician who is willing to treat their work injury as well. In the past 3 years, 1.2% of workers enrolled with the Majoris MCO accessed care through that avenue. Additionally, Majoris has always allowed chiropractors full attending physician status under the MCO oversight. And on average, about 2% of workers choose to select an attending physician with a chiropractor. This bill is really designed not to improve access for patients to quality providers. It is more set up to provide providers that otherwise would not meet the standards for MCO participation to have greater access to patients. And we would urge the committee not to support this bill that really is set up to undermine the existing workers' compensation system and MCO component of it. Thank you.
Thank you. Terry, do we have anybody else signed up for testimony?
Co-chair, I do not see anyone in the room, and I did not get any further public comment.
Great. As always, we invite folks that are unable to present at this time to submit written to Terry. We do receive copies of all of that goes in, and we do review that prior to every meeting, and appreciate the stakeholder and other engagement from folks. Next on the agenda, I see review of minutes from January 29th, 2026 that was sent out. Would entertain a motion if anyone felt inclined. Believe that was a motion from Sarah Duckwall. Do we have a second?
Second.
Sarah Merrick, motion and second. Any discussion? Hearing none. All those in favor signify by saying aye.
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 Any opposed? Any abstaining?
Aye. Since I wasn't here, I'm gonna abstain. Thank you.
Perfect.
Me
Thank
as
you, Sarah.
well. God, I wasn't here either. So I abstain.
Kim and Ryan.
Got it.
I never knew why we listed abstaining, and then I think there was a meeting that I missed 2 years ago and wanted to abstain from the minutes for that exact same reason. So it's one of those, you chair long enough, you learn why Robert's rules are a thing. Moving on, department updates, Workers' Compensation Board case law updates, Lauren Eldridge.
Good morning. Can everyone hear me? Okay. Good morning, co-chairs, members of the committee. Thank you for having me today. So there was a request that I discuss a recent Supreme Court case called Crandall versus State. So that's what I'll be talking about today, but I'm happy to answer any questions about this case or anything in our quarterly update also. So this case is what I like to call exclusive remedy adjacent. So this case does deal with whether workers' compensation provides an adequate remedy in a particular circumstance, but what it does not involve is the exclusive remedy provision of the workers' compensation statute. So under ORS 656-018, workers' compensation is still the exclusive remedy for a workplace injury against an employer. So a worker still cannot sue their employer for a workplace injury covered by workers' compensation. This case does not affect that statute. What this case does involve is a provision of the Oregon Tort Claims Act. And that provision provides that a person cannot sue a state employee for negligence in performing their state duties if the injury or death caused by the negligence is covered by workers' compensation law. So, next slide, please. Okay, so the question before the court in this case was, does that provision violate the remedies clause of the Oregon Constitution where the state employee immune from liability is a negligent third party? Okay, next slide, please. Okay, so to understand this case fully, you have to understand just a tiny bit of background about two things. The first is the remedies clause of the Oregon Constitution. So that clause exists in Article 1, Section 10 of the Oregon Constitution. It provides that every man shall have a remedy by due course of law for injury done him in his person, property, or reputation. So if a law deprives somebody of a constitutionally adequate remedy for purposes of this statute, that law, at least as it applies to the person, will be unconstitutional and unenforceable. Okay, so the second thing you need to understand just a tiny bit about is the Oregon Tort Claims Act. So what is that? If we go way, way back to common law, before we have a workers' comp system, before we have the Oregon Tort Claims Act, the Oregon Constitution gives the state something called sovereign immunity. And that means that you can't sue the state for its negligence actions that result in injury to you. What you could do is sue a state employee for their negligent actions. This created kind of dual problems. So first, it was bad for the injured parties because state employees are not going to have the financial resources the state of Oregon has to pay large settlements or large judgments against them. So ultimately, the state employee is probably going to become what's called judgment proof. They're insolvent, and the injured party is never going to be able to recover all the damages to make them whole. This was also bad for the state because the state takes on a lot of duties that are very high risk, have a high risk of liability. And so no person is going to want to work for the state in those high risk areas if they're going to be solely liable without any indemnity from the state for their negligent actions. Okay, so the Oregon Tort Claims Act is often described as like the solution to both of those problems. And what it does is in certain circumstances, the state comes in and waives its sovereign immunity, allows itself to be sued. and then it indemnifies its employees for their negligent actions. But the Tort Claims Act comes with certain limitations. For example, there's a cap on the amount of damages that a person can recover in a negligence action against the state. Also, in certain circumstances, the Tort Claims Act completely immunizes state employees from liability. So the provision at issue here is one of those instances. Okay, next slide, please. Okay, so with that background in mind, we'll turn to the case here. So the worker in this case was a firefighter working for a private employer. He was in a firefighting operation for his private employer and was very severely injured in an accident with a bulldozer. So although the worker was working for the private employer, the overall operation was being directed by the Oregon Department of Forestry. So there's no dispute here that the injury was covered by the private employer's workers' compensation coverage. But the worker also filed a negligence action against 2 ODF employees, alleging that they had directed him to operate this bulldozer in a way that was very dangerous and ended up causing his injury. The state moved to dismiss the negligence action, pointing out that under the Oregon Tort Claims Act, this injury was covered by workers' compensation law, and therefore the state employees were immune from liability. So the trial court agreed and dismissed the action. The Court of Appeals affirmed the trial court's dismissal, and the case made its way all the way up to the Supreme Court. Next slide, please. Okay, and the Supreme Court reversed. So the Supreme Court held that where the public employee is a third party, an allegedly negligent third party, this provision of the Oregon Tort Claims Act violates the remedies clause because it deprives the injured person of a constitutionally adequate remedy. Okay, next slide, please. So in doing so, the court set out the test for determining whether a remedy is constitutionally adequate. So that requires a weighing of the departure from the common law remedy against the legislature's reasons for modifying the remedy or eliminating the remedy. So this first part of the slide of the departure is a little bit incorrect. So just ignore that. Workers' compensation is not available under common law. So under common law, like we talked about with the Oregon Tort Claims Act, the remedy for this claim would have been to sue the state employees in a negligence action in civil courts and potentially recover both economic damages for things like medical bills and lost wages, and also non-economic damages for things like pain and suffering. So that would have been the remedy under common law. And the court said this remedy available to the person in this case is a substantial departure from that for a couple of reasons. The court first said workers' compensation benefits don't cover all economic damages, just some, and they don't cover any non-economic damages. Additionally, even under the workers' compensation scheme, third-party negligence lawsuits are allowed. So there's a statute, ORS 656-154, that allows an injured worker to sue for negligence a third party that maybe negligently caused their injury, even though they're also receiving workers' compensation coverage. So the court said because it allows workers' compensation, but not even the full benefit of the workers' compensation system. This is a very substantial departure from the common law remedy. Okay, next slide, please. Okay, so then the court looked at what were the legislature's reasons for departing from the remedy. They looked at 3 factors. 1, the state's need to indemnify its employees. 2, did the law provide a benefit that would not otherwise be available? And 3, what were the legislature's efforts to accommodate the interests of the injured persons that they were limiting the remedy of? So the court first acknowledged, yes, the state has a need to indemnify its employees, but our inquiry does not end there. Looking at what benefit the statute might have provided in limiting the remedy, they said there really isn't one. There is this limited workers' comp benefit, but the legislature did not even provide the entire workers' comp benefit because that would include a third-party action. And then the court said that it could identify no legislative effort to accommodate the interests of the injured person. Okay, so ultimately, the court concluded that the reasons for the law did not justify its departure from the common law remedy. And so here, for purposes of this case, it did not provide a constitutionally adequate remedy for the injured person. There was a dissent. Next slide, please. And 2 justices joined the dissent. The dissent is pretty straightforward. It really just says the workers' compensation system provides a sufficient remedy for purposes of the remedy clause in this case. It characterized the workers' compensation system and the Tort Claims Act as part of a comprehensive statutory scheme in which an individual loses the ability to sue state employees, but it gains the certainty of recovery through the no-fault workers' compensation system. And that is all the remedies clause requires. So any questions? I know that's a lot.
I see Patrick.
Yeah. Co-Chair Priest, go ahead.
Yeah. Thank you very much, Lauren, for that. So you may or may not know that my job, other than being co-chair, is for CIS, which insures cities and counties, and the Tort Claims Act is, of course, very important to our work with liability claims. This particular action, you say state, the forestry department. The Tort Claims Act applies to all public entities. So how does
that's
action
yes, it
relate
just
to-
happened to be a state employee here, but you are correct about that. Yes.
So this particular action would relate to cities and counties and, I don't know, universities and everyone else?
Yes. Yes.
Okay. All right. Thank you for clarifying that.
Of course.
The
Thank you,
second part of
Co-Chair
it is,
Yeah.
what was the injury that was not satisfied by the workers' compensation system? Like what was the additional, I don't know, harm that was caused?
So I think the court described, hold on, let me make sure I'm understanding the question. I think the court said under workers' compensation, there's no non-economic damages available. There's limited economic damages available. And then also, I think central to the court's decision here was the fact that under the workers' compensation system, if this were not a public employee, the worker could have pursued a third-party negligence action. And they could not do that here because of this provision in the Tort Claims Act. Does that answer your question?
So
Well, the question was more the nature of what was it that was not satisfied by the workers' compensation system. I heard like sort of, maybe it was non-economic damages, maybe some sort of just allowance for pain and suffering. I don't know. Rather than being medical bills or lost wages. Is that correct? Yeah.
Decision, yes.
great. Thank you. I see Ryan.
Yeah, thank you, Co-Chair Priest or Strickland. Sorry about that. Thank you, Lauren, for going through all that. I really appreciate it. I know how complicated these can be, and to lay it out in layman's terms. Curious if this has any effect on contractors with public employers.
Good. That is a great question that I do not know the answer to.
Okay. Yeah.
But yeah.
Thank you. I'd be curious to know.
Yeah, I can look into it, certainly.
Okay. Thank you.
Of course.
Thank you. Any other, Patrick?
I have one more question. Do we know, I know, so this was, there are additional, so this was the Oregon Supreme Court
Yes, that's right.
found this, and they sent it back for further review, right? It's not over, it'll be reevaluated.
Yes, exactly. So this was remanded to the trial court, and this was just the Oregon Supreme Court's decision about whether the plaintiffs in this case can pursue their negligence action. This has no effect on whether that negligence action might be successful going forward.
Thank you for clarifying that.
Yeah, of course. Yeah.
Do you know, since you work for the state, but I know it's a big entity, what is
Yeah.
the state's approach? Do they feel this was a good ruling? Are they going to, I don't know, try to, appeal in some way? Do you have any thoughts on that?
Yeah, I do not have any sense of that from like a policy level. Yeah, I think because this interprets the Oregon Constitution, the Oregon Supreme Court's really the court of last resort. So it might entail a constitutional amendment or something. It would be hard to change. Yeah.
Thank you.
Sounds like we will be able to look forward to you coming back and presenting some updated information as this
Sure.
proceeds forward.
Yeah, absolutely. Okay. Thank you.
Thank you. All right. Next up, I see Workers' Compensation Division updates from Terry.
Yes, I have a couple updates on offsite meetings. On May 7th, our MLAC meeting will be held in the afternoon at the Workers' Compensation Ed Conference in Wilsonville at the Holiday Inn. There's more information coming about that. And then our June meeting, June 16th, which is a Tuesday, will be at the OSHA Blue Mountain Conference. And more information will come about that soon. Let's get through session first. The last thing I just want to say, during February, we've opened this room, conference room F in the basement, for everybody to come and join us if you want to.
Great. Thank
like
you.
there's-
Yeah, I see a question from Sarah.
Thank you. Terry, could
Yes.
we get placeholders sent for our calendars on those?
Absolutely, that's a great idea.
Thank you.
I will do that. And actually, I need to toss it over to Administrator West.
Great, thanks, Terry. Co-chairs, members of the committee, Matt West, Workers' Compensation Division Administrator. Quick update, will not be nearly as fascinating as everything Lauren just shared. So I just wanted to give the committee a quick rulemaking update for WCD. So on January 29th, we published proposed rules for Division 9, 10, 15, and 35. So the medical rules, that update that we do every year. Those rules are out for public comment. They'll be open till February 25th for folks to weigh in on the proposed changes. And we have a virtual hearing scheduled on February 18th if anyone wants to comment. And then Division 180, which are the rules related to worker leasing companies or PEOs. You may recall House Bill 2800 in 2025 made some changes to worker leasing companies. And we have started the internal process of rulemaking and then expect to have external meetings later this spring related to Division 180 with the hope of wrapping it up pretty quickly. The bill gave an effective date of July 1 of 2027. And because we anticipate some changes that insurers and PEOs may need to make to their systems as far as reporting, we want to try to give a long runway to allow for those changes to happen. So more to come on that as those external meetings are scheduled. That's all I had.
Great. Thank you. And would reiterate Sarah's request for placeholder meetings. I know that that's very helpful, especially leading into the year as things start to fill up. So good flag there, and thank you to WCD staff for getting those sent out. Next up, I see 2026 bill presentations, starting off with SB 1519, and I see we have a -2. Odalise.
Good morning. Oh wait, can you hear me?
Yes.
Hey, good morning. There is a -2 posted on OLIS. There's a summary posted as well for the record. The -2 came from a slight technical change from SAFE and WCD for catching it. I'm actually gonna toss it to Evo if you want to explain the -2 that we're okay with and we've agreed to. Or Elaine.
Yeah, if Elaine is on, maybe she can slowly join me.
It's very technical.
Yeah, it's very technical. Basically, the -2 is the -1 one more time. There's one small change that just brings it into it solves a tension in the statute that the -1 would have perhaps created, and just brings how we pay time loss payments if they straddle the July 1 increases, how we pay them and calculate them, and it just kind of solves that issue. But basically, it makes sure that it only applies to injuries, claims with an injury date on and after January 1, 2027. So it clarifies it's not retroactive. It only looks forward. It clarifies that for permanent total disability, the current minimal payments of 33% of SAW are kept with this bill. That was not clear earlier. And I think that's the changes that the -2 makes. Elaine, what did I miss?
I think you covered it. It clarifies that the wage, the average state average weekly wage that's used is the one in effect on the date of injury. And then there can be a cost of living adjustment if the state average weekly wage increases. And so that adjustment is based off of 656-211, and it references 656-210. That cost of living adjustment now falls under subsection B in 656-210-1. So adding the little b to 656-211 and its reference to 210 subsection 1 clarifies where that cost of living comes into play, and it's a clarification there. It doesn't change the overall initial calculation of the time loss rate. That still remains as of the date of injury, but it clarifies that that cost of living adjustment, if there is one, can be applied then.
I just want to add, maybe kind of put a bow on it. This amendment makes it that the bill becomes implementable from the insurer's perspective. It's technically doable and all that. It accomplishes everything we think that the subcommittee kind of came to a conclusion on. SAFE will remain neutral on the bill due to the increases, but I just want to say kudos to MLAC, the subcommittee, the stakeholders. I think in the end, this reflects sort of what MLAC is all about, collaborative, long drawn out detailed process. I mean, this has been going on for, it feels like 1.5 years at this point. So kudos to all the stakeholders who got this done. The amendment works. Thank you.
Great. Well, thank you for that. And I know that we have some of the other stakeholders in the room too. I believe AGC, I don't know. I know that OBI was involved in the process previously. It's my understanding that this amendment as presented kind of keeps with the recommendations and the work that the subcommittee had achieved, and that everybody's sort of agrees that this bill would be the proper implementation of that. This bill as amended, let me say, it would be the proper implementation of all of that wonderful work from stakeholders in the subcommittee. Is that accurate?
Chair Strickland, Kirsten Adams with AGC. Yeah, it's our understanding that this was mostly a technical piece that hadn't been caught before. So I don't think it changes anything in terms of what we're trying to do with the substance of the policy. So we're good. Thanks for asking.
Perfect. Thank you. The work of the subcommittee was pretty much just propping up and engaging stakeholders, and I want to make sure that we're not interfering with that momentum. So really appreciate all the stakeholder engagement on that and through the subcommittee on this. So it's my understanding we'd be looking for MLAC vote on this as presented then. Seeing a thumbs up from Odalise. I would call a quick caucus just for management and labor folks to discuss things, and then we will return from that shortly. Terry, if you'd like to shuffle us all away to, oh, there we go. There's the invite. Thank you.
Okay.
Perfect. Welcome back, everyone. I guess I will make a motion to support the bill presented as amended, in that it keeps with the recommendations of the subcommittee and all the work that was done from stakeholders.
I second the motion.
Motion and a second. I can kick off the discussion too. I just want to really thank all the stakeholders on this bill. There were many months of engagement on this issue, and this work could not have been done without that constant stakeholder expertise and engagement. I think that was very helpful, and I want to thank Stacy in particular for her tireless efforts on the subcommittee as well. I know that was a ton of work, and just appreciate everyone's work on this process. Sarah.
Thank you, Scott. I also would like to thank on behalf of MLAC, you and Stacy both being part of subcommittees is an extra task that you are taking on from your volunteer role. So we appreciate that work from both of you as well. Thank you.
Thank you. So motion and a second. All those in favor signify by saying aye.
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 Any opposed? Any abstaining? Okay, that motion passes. And I see next up we have SB 1506-1 and HB 4027-1. Josh Nasby.
Members of the co-chairs, members of the committee, my name is Josh Nasby, and I'm with the Bureau of Labor and Industries. Thank you very much for your time, both today and over the last couple of weeks. Very grateful that you'd be willing to spend your valuable time with us. Back before you today because final amendment language was produced yesterday afternoon. There's been identical language drafted as -1 amendments to both Senate Bill 1506 and to House Bill 4027. And I know we've talked about these policies in detail these past 2 weeks, so I'm going to walk you through the amendments pretty quickly. Going out of order, you'll see the prevailing wage fee cap increase in Section 11 of the -1 amendment. The increase to that cap does not impact a workers' compensation system in any way. Sections 1 to 10, and perhaps sort of more specifically, sections 5 and 7 create the process we've been discussing, a process that utilizes the Workers' Benefit Fund collection and distribution infrastructure to fund a portion of the Bureau's operations. We've heard loud and clear the concerns with Senate Bill 946 from the 2025 legislative session, and we have done everything in our control to improve the drafting and respond to the concerns you all have raised. We've heard, we understand, and we agree with your concerns around ensuring that there is no negative impact to the workers' compensation system. To achieve that goal, the draft amendments create an entirely separate and distinct account, the BOLI Expenses Fund, to house monies separate from the Workers' Benefit Fund, and you can see that in sections 2 and 3 of both amendments. There is a complete prohibition on transferring monies from the Workers' Benefit Fund into the BOLI's Expenses Fund, and you can see that in Section 9, subsection 5. You will see clear language ensuring that the two assessment rates are determined independent from one another before they are combined, and you can see that direction to DCBS in Section 5.4D. The amendment now contains what I think we described as guardrails last week. The initial bucket of positions will not exceed the cost of the temporary positions that were funded by the Workers' Benefit Fund in 2025. And the second bucket of positions now has a hard cap at the number of positions that cumulatively cost $5.25 million on July 1, 2031. You can see these safeguards in sections 5, 6A, and 6C, and in sections 7, 6A, and 6C. In addition, yesterday afternoon, Senator Taylor read the following into the record yesterday, and I understand it was at the request of management representatives. Senator Taylor said, and I'm mostly quoting here, "First, I have a statement I'd like to read into the record to create legislative intent for Senate Bill 1506. If passed, I will ask the Bureau of Labor and Industries to make annual reports to this committee on how the funding allocated by this measure is being spent and used. I intend for BOLI to use these dollars in accordance with their mission to protect employees and support employers. I will also ask the Workers' Compensation Division to include the BOLI's Expenses Fund in communications to ratepayers, breaking down the Workers' Benefit Fund rate. In short, Senator Taylor and we at BOLI have heard your concerns about the workers' compensation system, and we've worked at length with DCBS and its Workers' Compensation Division to ensure that those concerns are directly reflected in the drafting of these amendments. Both -1 amendments proactively ensure that every penny in the workers' compensation system stays in that system so that there's absolutely no disruption to the programs funded by the Workers' Benefit Fund. And again, members of the committee, I'm very grateful for your time. Happy to answer any questions you may have.
The question from Sarah.
Thank you, Co-Chair Strickland. I don't see any reference to what the initial assessment will be. I know before we had a number of 0.02 of a penny. Will that be the same amount we're looking at initially, or will it be something different?
Co-chairs, Ms. Stockwell, I should defer to DCBS on this. My understanding is they have run the numbers, but I believe the answer to your question is yes. The initial assessment will start out at 2/10 in total, 1 cent for employees and 1 cent for employers.
Thank you.
Co-Chair, Director O'Day is in the room and can answer further.
Perfect. Yes, please, Director O'Day.
Thank you, Co-Chair Strickland. Yeah, Ms. Stockwell, great question. I agree with everything Josh just said, but I do want to put a couple caveats on it. As I've shared in other forums, the way that we set the rate is we do that based on economic projections from data that we gather during the summer, and then we set the rate in September. And so it's going to be economically dependent. The way the trend lines are looking right now, as we do that analysis, it is 0.2 cents. But the economy could change. It could get better, or it could get worse by the time that we set the rate. So that's why you don't see the rate set in statute or referenced anywhere, is because we need the flexibility in order to be nimble when setting that rate based upon the economic circumstances we're facing at the time.
Thank you. Just looking for an estimate, which you provided. I appreciate that.
And I see a hand from Patrick.
Thank you, Scott. My question is, I heard in your comments some ongoing work by MLAC, some sort of, we would be reviewing, future reports about this fund or this sub-account of the worker benefit fund. And I just kind of wanted to understand what the expectation was going forward for MLAC's role.
Thank you for that. So I think I was describing, I think I was describing a different committee, Senator Taylor's committee. Senator Taylor indicated that she wanted us to report to her committee on an annual basis about the use of the funds. The bill draft does have a role for MLAC to play in assessing changes. If in the same way that you assess changes to the worker benefit fund, you will have the opportunity to review those changes to the BOLI expenses fund. But the reports I described earlier will go directly to the Legislative Assembly. Happy to get you copies of those, though.
So the ongoing oversight that MLAC has of WBF would extend to this as well. Is that the clarification?
Yes, sir.
Great. Thank you. See another hand from Sarah.
Thank you for letting me ask another question. On the House bill side, this is the first we've heard of that. Can you explain that, just that process? Will they go in tandem together? What is the thought there?
I think the current thinking is they will go together. It's a fairly fluid process, but the current thinking is yes.
And that bill that's been proposed is a mirror of the bill that was presented on previously. Is that correct?
That is correct. The amendments are identical.
Okay. Thank you. I might recommend a brief caucus if possible. And then please make yourself available for additional questions if needed. Mr. Nasby?
Co-Chair, it's Terry. I just want to make one quick statement. Bills are introduced identical on both sides of the chamber often. Sarah, this happens frequently. So this is not unusual. I just want to say that, okay?
Thank you for that, Terry. Yes, that I know that in on my day job, that is a technique that we utilize frequently. But yeah, so perhaps a brief caucus and then we can come back.
Yes.
That's fine.
Thank you. Okay. So I understand that we had some good discussion. If folks are ready for a motion, I would entertain one. And then we'll still have discussion, obviously, after the motion's made. I see a hand from Patrick.
Thank you, Co-Chair Strickland. I'm happy to make a motion. And this is starting out by just stating that we appreciate the continued engagement with MLAC by the legislature on the importance of issues of the workers' compensation system. And although we don't opine on the bill as a whole as drafted and with the assurances put on the record by Senator Taylor on February 4th, we are comfortable that the subaccount for BOLI expenses will not negatively impact the workers' comp system. And we ask that should any further interest in utilizing the worker benefit fund mechanism arise in the future, we expect that MLAC will be engaged in those conversations.
I would happily second that with the understanding I think we'll have a letter or something that kind of lays all of that out coming from us as MLAC, and I'm seeing head nodding, so I will second that. Any discussion? Seeing none, all those in favor signify by saying aye.
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 Any opposed? Any abstaining? Seeing none, thank you, Patrick, for that, and for Mr. Nasby for your work and continued engagement on that and making yourself available to answer concerns and other things from the committee members. Appreciate that.
Just want to say a quick thank you to you all for your work. Thank you.
Thank you. So rolling right along, I see up next we have HB 4040, Taylor Sarman.
Yes, hi co-chairs, Taylor Sarman on behalf of the Oregon Society of Physician Associates. Just a reminder, I was here 2 meetings ago to talk to you about adding nurse practitioners and physician associates as attending physicians for workers' comp patients. I told you and previewed a brief technical amendment that we have asked for and we received this morning. I don't know that you all have gotten it yet. It is on OLIS. I will pop it into the chat just if folks, actually I won't because I can't, but it's on OLIS. That's the -19 amendment. I'll walk you through it just really briefly. Again, it's all technical in that there's some language that.
Apologies, if we could pause for 1 second, would it be possible for our WCD friends to pull that up and screen share on that amendment?
It is in House Bill 4040 in the legislation 2026 folder. Chris, just keep talking and we will get it up on the screen in just a moment.
Taylor.
Taylor.
Yes,
Sorry.
thank you. Please continue. Apologies.
So it's the -19. The first change that you'll see in the amendment is just really, I think, clarifying some language about providers who are a similarly licensed physician, a similarly licensed surgeon, a similarly licensed nurse practitioner. When the nurse practitioner language was added, they inadvertently, it caused some confusion about whether a similarly licensed maxillofacial surgeon could be the attending physician. And so the first part of the amendment really just clarifies that it's all a similarly licensed physician in another state or country. I think probably the most substantive of the changes, which again, substantive in the sense that these are all still very minor and technical, is that we added on page 62, line 7, that the administrator could consult with the Oregon State Board of Nursing, so that nurse practitioners could be arbiters. Previously, it didn't include the Oregon State Board of Nursing, and so again, we just wanted to add that because they will be included in that. If you all approve and the legislature approves, they'll be included in that definition of attending physician that's already in the bill. And then similarly, just keeping with the cleanup on page 71, line 37, it just adds the language that's consistent with the language at the top of the amendment about nurse practitioners similarly licensed in a different country or state. So Again, very minor, very technical, no major changes in this -19 amendment. So we'll pause there and see if folks have any questions.
My compliments on making it to a -19 in the first week of session. That's very impressive.
We're not the highest dash. There's a 21, and I imagine that there will be several more dashes for this bill.
Any questions? Thoughts, comments?
Co-chair, I will get the amendment out to MLAC members as soon as this meeting is over, okay?
Perfect, thank you. And as oh, there's some hands. I see. I'm going to go to Sarah first and then Evo.
Thank you, Co-Chair Strickland. Just a quick clarification. Taylor, you mentioned this might not be the last dash. How should we act on it if we're expecting further information?
My apologies. It's the last dash that I will care about, and I hope that you all care about. I imagine, given the relating to clause of this bill, other folks will have amendments that flow into it. But for our purposes, in terms of changing attending physician status for nurse practitioners and PAs, this is it. This is the final thing.
Thank you.
Yeah, and so I guess kind of following up with that, that's a good point, Sarah, as this is an omnibus bill and huge. This -19 is sort of the last thing that touches MLAC's purview. Is that what you're suggesting?
Yep, that's to the best of my. It's the only one I'm responsible for. So,
okay, appreciate that. Evo.
Yeah, maybe just to clarify, that's the only one that we've seen, the only section that deals with work comp that we have seen that we care about too. So we'll keep watching for the relating to clause, but this is the only one. I just wanted to clarify, we at SAFE, we took a quick look at the amendment. It covers all the changes that we also asked for, and it works for us. So thank you.
Thank you. Any other questions or comments? Not seeing any. I'd propose a brief caucus on this one, if management is amenable.
Yes.
Okay. You can send us away to our rooms, please, Terry. Thank you.
Can you see, are we on mute?
So
Scott?
it's my
Scott?
understanding that we
Oh.
have an elected with us
Are we muted?
presently.
Yes, yeah. Can
And
we?
so, yeah,
Oh, go
so
ahead.
what I'm going to recommend is that we or I will just say we're going to momentarily table the discussion of HB 4040 and we will move on to allow Rep. Munoz to present. Please go ahead.
Okay, thank you. I thought you were making a motion and people were gonna vote on it. So I was waiting.
No
Hello,
worries.
everyone. It's a pleasure to be here with you today. My name is Leslie Munoz and I'm the state representative for House District 22, which is Woodburn, Jervis, Brooks, and North Salem. Thank you for the opportunity to testify today in support of House Bill 4119, a measure that aims to strengthen fairness and access within Oregon's managed care system for injured workers. Workers' compensation should function as a safety net, ensuring that injured Oregonians can access timely, appropriate, and high-quality care. Currently, some managed care organizations, MCOs, plans have contractual provisions that can limit an injured worker's choice of provider or make it difficult for certain qualified providers to participate. HB 4119 directly addresses these barriers by ensuring that no certified MCO plan can discriminate against any willing provider within its service area, regardless of what the provider's professional designation or affiliation. This provision will protect worker choice and increase provider participation in workers' compensation networks. When injured workers have greater access to competent and willing providers, they have a stronger chance of returning to work sooner and with better health outcomes. Removing discriminatory barriers also supports fairer competition in the healthcare marketplace, which can improve access, especially in rural or undeserved areas. Importantly, HB 4119 expands the definition of who may serve as an attending physician to include nurse practitioners, physician associates, chiropractor physicians, and naturopathic physicians for the purpose of treating workers' compensable injuries. I'm sorry, I'm distracted. They're calling me from the floor. These professionals are highly trained and often primary points of care for many Oregonians. Their inclusion reflects a modern, team-based approach to healthcare that recognizes the value and expertise of all licensed providers, or that all licensed providers bring to injury treatment. This change will help ensure that injured workers can see the appropriate provider without unnecessary referral hurdles, and that they can benefit from culturally competent care delivered by providers with strong community ties. Our workforce depends on workers' compensation system that is fair, accessible, and responsive. By preventing discrimination in managed care contracts and broadening who can serve as an attending provider, HB 4119 takes important steps towards these goals. I urge this committee to support HB 4119. Thank you.
Thank you, Rep. Munoz. Do we have any questions before we allow Rep. Munoz to get back to the important business? Patrick.
I don't have a question. I just have a comment. I want to thank you, Representative, for taking the time to present before MLAC. It really means a lot to have a representative take their time and come from the floor in your important work. Thank you.
Thank you. I appreciate that. I guess I have a question if that's appropriate. I don't know how MLAC works.
No,
I'm new.
please. Yes, of course.
Yes.
Ask away.
So, what is the process of me knowing where my bill sits with MLAC after this meeting?
I will let Terry jump in if I'm incorrect on the analysis, but typically, as bills are drafted and are in the pipeline, they take a quick stop at MLAC for if they are within our purview. We then make a recommendation either to support or not support based on testimony and stakeholder engagement. As soon as we have a determination there, we draft a letter signed by the two co-chairs kind of indicating what action, if any, was taken, and get that submitted back to the legislature and typically the committee and the proponents.
Okay, well, thank you very much. Thanks for having me. And I'm sure we will meet again because I'm on the Labor Committee and then also on healthcare. Thank you so much for your time.
Great, thank you. We appreciate it. So, having that testimony, we're going to pause. We will go back to any potential motion on HB 4040. Apologies for shuffling things around. I just wanted to make sure that we had, we're being mindful of representatives' time. I see Emily has her hand raised.
Hello. I move that MLAC approve HB 4040 with the -19 amendment.
We have a motion. I see Kim has her hand up.
I second the motion.
We have a motion and a second. Do we have any discussion? I see Sarah.
Thank you, Co-Chair Strickland. I just wanted to state that I think this is an exciting time to address access to care and the issues that have been before us with access to care. So I'm looking forward to this moving forward. And I would like, when that is addressed at some point in the near future, to retake up the conversation at the MLAC level to end open-ended time loss. Thank you.
Thank you, Sarah. I hear you on that and want to reiterate, I know that we had a commitment from labor a long time ago to continue in discussion of that concern. And I want to restate that we are committed to kind of upholding our end of continuing that work and discussion. So appreciate that. So we have a motion, a second, some discussion. Do we have any other discussion? Seeing none, all those in favor signify by saying aye.
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 Any opposed? Seeing none, any abstaining? Okay, the motion passes. Switching back to HB 4119, I know that we have Rep Munoz's testimony. I see also Dr. Sabo listed as signed up to provide testimony about the bill. Is Dr. Sabo available? I see you there, Dr. Sabo. Please take it away.
Yes. Our focus should be for all stakeholders to ensure that Oregon injured workers receive timely access to evidence-based, safe, effective, and respectful management of their on-the-job injuries. You heard what 4119 does, and I'm not going to take up the committee's precious time. We were anticipating the summer interim task force meetings to review the facts, drill down through data and the medical evidence relative to do those support removing the restrictions on physicians assistants, nurse practitioners, physicians, chiropractic physicians, naturopathic physicians. Is that in the best interest of injured workers receiving and prompting them to get access to timely, effective, evidence-based care? And so I look forward to those meetings, and I urge your aye vote on 4119. Thank you.
Thank you, Dr. Sabo. Do we have, I see Evo has a hand up?
Yeah, thank you, Mr. Chair. And my apologies, I didn't technically sign up to testify, but I submitted written testimony, and I will keep it short and refer to the written testimony on the record and post it to the MLAC's site. SAFE opposes House Bill 4119. Basically, I will summarize 3 points here. And then there's more in the written testimony. One, we oppose it on the limitations to the MCO. I want to echo Ian Klein's comment from at the beginning of the meeting. It is not in the best interest of the system or in the delivery of quality care. Two, I want to point out chiropractors can already serve as attending physician for the first 60 days or 18 visits, after which there's a scheduled transition to another attending physician who may or may not approve continued ongoing chiropractic care, depending on the case and the best interest of the worker. And three, we are in the end concerned about costs. We looked at all claims and compared the same kind of type of claims where chiropractor serves as attending physician for the first 60 days to when another provider, any other provider, serves for the same 60 days. Over the life of the claim, the total medical cost and the total physical medicine costs are always higher when an attending physician, when a chiropractor, serves as AP. And we are concerned that should HB 4119 pass, that this would just mean an increase in costs to claim costs, impact employer premiums. And I want to remind people, and I don't think I need to remind people, but you just approved a bill earlier today that will increase costs. There's got to be a limit, and we are concerned about that. For all these reasons, we oppose the bill, and we respectfully ask that MLAC also oppose the bill. Thank you.
Thank you. I see Kirsten and then Thijs.
Thank you, Co-Chair Strickland. I am in the same boat as Evo. I apologize for not signing up for testimony, but did want to offer EGC's perspective on this. As you just heard from SAFE, a lot of our members are insured by SAFE, and so obviously their concerns become our concerns on a lot of these issues, but particularly the cost implications that he was discussing. I see the importance of having conversations around access to care and making sure that everyone is able to get the care they need within the system. I do have concerns, however, looking at what SAFE has pulled and discussed in terms of cost implications to this particular change to the system. I also agree with the comments brought forth by Anne Klein earlier about concerns that about the control over MCOs and not allowing them to have what they need or the discretion that they need. I know that talking about MCOs has been a piece that's been on the MLAC work plan. So I think if that is a concern that MLAC wants to dive into, I think that talking about it through the work plan and then figuring out what the best solution is, as opposed to making a change without a deeper conversation at MLAC. So thank you for the opportunity to give our perspective. And we would second SAFE's recommendation that SAFE not, or that MLAC not move this forward at this time. Thank you.
Thank you. I see Thijs and then Dr. Sabo.
Hi, Thijs Womack with Sedgwick. I apologize. I'm having some camera issues this morning. To keep it short, we have evaluated similarly to SAFE those outcomes and costs with chiropractic care, not just within the state of Oregon, but actually nationwide, and have come to similar findings. We concur with both SAFE's statements and with Anne Klein's concerns that were expressed earlier today with this bill.
Thank you. Dr. Sabo.
Yes, thank you. In response to Evo's comments and also Ms. Klein's comments relative to the MCO's open panels and the system working currently, I will use Majoris as a perfect example of how it is not working respectfully in our opinion. Majoris's MCO panel in the Woodburn area, there isn't a single chiropractic physician on panel in Woodburn, Turner, Silverton, or Molalla. Of the 16, I would say there are 16 or 18 providers, other types of providers listed. We did our research, only one individual actually will accept workers' comp cases on their panel. That's a nurse practitioner in Woodburn. As to costs, we've heard repeatedly the supposed data from SAFE Corporation. I met with Evo and Elaine before the 2005 session. I presented them with 87 pages of peer-reviewed journal medical articles showing the outcomes and superior cost savings of chiropractic care. And relative to nationwide statistics, I would refer you to the Workers' Comp Research Institute. Now, the Workers' Comp Research Institute is an independent, nonprofit research organization providing objective peer-reviewed data on workers' compensation systems. It's considered the gold standard for analyzing public policy, medical costs, and outcomes for injured workers. It does not take positions, but rather supports evidence-based decision-making for policymakers and stakeholders. To that end, until 2021, the Workers' Compensation Research Institute performed a study on the chiropractic management of injured workers. This was a study of 2 million claims across 28 states. Their conclusions were it resulted in a 61% lower cost overall when injured workers treated exclusively with a chiropractic physician. Case average was $1,366 versus $3,500. Time loss with chiropractic physicians managing the case was an average of $492 versus $3,600. 1% of the chiropractic patients at some point received an opioid versus 10.3% for other healthcare providers. And so we would argue that SAFE Corporation's data referring to, and I'm looking at January 14th email that Representative Rob No sent to me that in the subject line said feedback from MLAC. His first sentence was, here's what we heard back from MLAC, when in fact, this is a document from Safe Corporation. In that document, it cited that the average visits for a chiropractor was more 10.5 over 60 days versus 5.4 visits to other provider types, MDs, PAs, nurse practitioners, and DOs. And we would tell you that the 5.4 visits to the other providers does not constitute hands-on treatment. It is in fact for consultation examinations. And generally those providers prescribe medications and or a course of physical therapy, usually both, and those are direct medical costs. And so the question that I would have for Evo and Safe Corporation, what is the average claim cost for physical therapy prescribed by one of these other healthcare providers? Our research by the same Workers' Comp Research Institute suggests that it is between $4,000 if they get the physical therapy within 3 to 7 days. If it's delayed to 60 days, that same physical therapy case averages slightly over $5,000. Thank you for your time.
Thank you, Dr. Sabo. I see Ann Klein has a hand.
Hi, yes, sorry, it took me a minute to get off of mute. I just wanted to respond to Dr. Sabo's comment regarding Majoris's panel limitations. And we do recognize that there are certain areas of the state where we have maybe not as robust of options as other areas of the state. I have a provider relations team where their responsibility includes both proactive outreach to providers of all specialty types to address those limitations where we can. In 2025, of those that we proactively reached out to, oftentimes because we saw past experience in treating workers' compensation or in treating an individual that was enrolled, and perhaps we had opportunity to partner with them in the come-along privilege provision. We reached out, only 18% responded with openness to contracting, and of those, 4% ultimately resulted in agreeing to contract. There's certainly more limitations than just willingness to treat workers' compensation. It's also how it aligns with their overall practice and the availability that they have and what they're seeking to focus. In addition, we also regularly receive inbound membership applications for consideration of network participation. In 2025, we received 84 applications from all different provider specialty types. 56 of those we extended contracts to, specific to the chiropractic specialty. Of those 84, 20 were from chiropractors, and we are in active contract discussion or executed contracts with 17 of those.
Thank you.
Thank you.
Yeah, it was my understanding. I know, I think a session or two ago, we had a bill addressing MCOs and coverage and all of that. I think that was referred to subcommittee. It would be nice to see that again, but I know that that's not before us currently to kind of continue the work plan discussions on that. So I appreciate that data and information. I see Evo.
I just want to respond briefly. I am familiar with the Dr. Sabo, the study he quoted, the 2022 Workers' Compensation Research Institute. I want to say I agree with him. It is the gold standard in research for workers' compensation. That study looked at 28 states across the nation, about half that had some sort of employer control or selection of providers, about a quarter has limited employee choice of providers, and another quarter has no, where the employee can choose whatever provider they want. The study did not include Oregon. It's the 28 states. It's the averages across those states. The study authors agree, even say it raises other questions about what it explains the differences across states in terms of utilization review, treating guidelines, limits the number of visits. I would add, what are the fee schedules? Every fee schedule, medical fee schedule is different, or is it reimbursement of percentage of billed, et cetera. Every system is different. If you know one system, I'm going to quote David Bernberg. I hope he's watching. If you know one system, you know one system. Yeah, I understand these numbers. Our numbers show what our numbers show. And I understand Dr. Saber doesn't like him, but that's what our numbers show. Thank you.
Any other discussion? I want to be mindful as we are approaching time to provide time for caucus and additional discussion and questions. Perhaps a brief caucus. I know that that was a data-heavy presentation on all sides. Perhaps a brief caucus to allow folks to digest some of that information, discuss. All right. So Terry, if you want to send us away to our rooms, thank you.
Okay, there you go. Okay.
Oh.
Everybody should.
Okay, do we have everyone? Looks like it.
I believe
All
so.
right. So, had some discussion, good discussion. I want to thank all the stakeholders for presenting the information. I think that was really helpful in sort of analyzing this. And I know that there's, a lot of that data and information that we've kind of had presented before. And I think that bringing this up again was helpful and sort of touching on all of those things and illuminating a lot of that data for us. Want to thank the passionate contributions of stakeholders as well. I understand this is kind of a big issue for a lot of folks. That all said, I'd be open to a motion if anybody would be interested in making one, or additional questions or other things. I see Ryan raised a hand.
Yeah, I make a motion to not approve House Bill 4119, or not to support.
Thank you. There's a motion to not support. I see Emily has a hand.
Second the motion.
So we have a motion and a second. Any discussion? Seeing none, all those in favor signify by saying aye.
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 Any opposed? Any abstaining? Motion carries. I want to again thank everybody, MLAC members especially, for the fun couple weeks that we've had here in the race to get underway under short session. And thank stakeholders without whom this job would be impossible, for all the information, guidance, perspective, and everything that they bring forth. Sounds like we have a few letters that we need to get drafted so that we can get co-chair signatures on those. I know Terry gave a bit of an update on the upcoming meetings, but I do see that on the agenda listed. Upcoming meetings, March 5th, April 2nd. Go ahead, Terry. I'll let you have more information than I do, so I'll let you state that.
I was just gonna say, I'm gonna hold February 12th and February 19th in case anything comes up legislatively. I will cancel those meetings if we don't need them. We have a meeting March 5th. April 2nd, we have an OSHA presentation on the regulatory and consultation. We have the Administrator Renee Stapleton coming in to give an overview of OSHA. And then May 7th is our WCD Ed conference. If you want to attend that conference, I've heard from some of you, but not all of you, please get me that information right away so I can get you signed up for that conference. That's it. You guys rock and roll today. Congratulations.
Perfect. Thank you as well to WCD staff, also without whom we could not do this. So appreciate everyone. We are 1 minute over, but not too bad for taking action on everything before us. Thank you, everyone. I wish you a safe and happy rest of your day.
Thank you.
Thank you.
Thank you.
Bye, everyone.
Bye.
I have a question going back to 1506. I guess they haven't voted on it. They don't know.
Hold on.
So